So a parenting plan is a document that is filed with the court that's either arrived at by a resolution or agreement by the parties, or it is an order of the court after a hearing or a trial. And a parenting plan basically spells out every aspect that you can think of with respect to the minor child's life. What's the time sharing schedule going to be? What's child support going to be? What's holiday time sharing going to be? What is a parent going to pay for in terms of reimbursement for extracurricular activities? Any kinds of tax exemptions, where the child goes for vacations. But it basically delineates to both parents all the responsibilities that are needed for the child and kind of spells out as a default what's going to be happening with the child in terms of time sharing with both parents. Yes, if you're going through a divorce and you have minor children, then you most certainly need a parenting plan. Florida Statute 61.13 is going to require that there is a parenting plan that's put in place, and there are certain required elements that have to be included in that parenting plan, or else it will be considered void. Also, if you're going through a paternity action, then you will also need a parenting plan. Time sharing is decided by the court under 61.13 subsection 3 based on a best interest of the child determination. Now, there are 20 factors enumerated in that statute that will guide the court in fashioning a time sharing schedule that serves the best interest of the child. The ability of one parent to foster and encourage an ongoing parent-child relationship with the other parent. Sometimes when the child reaches a certain age, generally around 15 or 16, the child's preference can even become a factor to determine, the best interest of the child and the parenting plan. If you have to go to court and you go to trial on time sharing, essentially what you're going to do is you're going to have to give testimony on each of those factors to try to demonstrate to the court what the best interest of the child is. Now, it's not an exhaustive list. You can certainly include any other factors that are relevant to determining what serves the best interest of the child. It's always better to try to go into a mediation and try to work on a time sharing schedule together with the other parent rather than having a judge decide it, especially because the judge doesn't know you, the judge doesn't know your children, it doesn't know what your family dynamic is. It's better to try and co-parent and mediate it, but if not, the 20 factors enumerated under that law will guide the court to decide what the best interest of the child is to fashion the time sharing schedule. No, there is no presumption in favor of one parent or another. This is also pursuant to Florida Statute 61.13. There used to be what's known as the tender years doctrine, which pretty much stated that when children are in their early formative years, because they're of a tender age, then it's more important for them to be with the mother. However, that has since been abrogated by the Florida legislature, and there is no presumption in favor of either the mother or the father, or sometimes the mother and the mother or the father and the father. Hi, my name is Kevin Vagovic. I'm an attorney in Daytona Beach focusing on criminal defense, family law, and general civil litigation. Visit us on the web at vagoviclaw.com or give us a call at 386-265-0900.